Okay, so before going into 2016 peace agreement, I want to answer some of the questions. And I will ask them in this order. First, Maria asks about whether the special tribunals of chambers created to deal with these crimes, or was it the same ordinary courts? Um, it was the ordinary jurisdictions in this first peace agreement that took on these matters, and the investigation was carried on by a special wing of the prosecutor's office, but it stayed being the prosecutor's office, and it was just normal prosecutors who were sent to work for these specific crimes, and they developed an expertise during the years, but that were not, it wasn't a different body. Um, and what was the reaction to Colombia to that law? Um, Colombia is a very polarized country, and therefore it's hard for me to answer that question directly. At that time, there was a lot of support for a military end to the armed conflict, and people were very tired of guerrillas, and saw in a way this process of negotiating with paramilitary actors not as the worst thing, as there was certain support for their actions within the conflict. However, regarding the victims themselves, a lot of them heavily complained about how this granted hidden amnesties to the perpetrators of massive violations of human rights. And many NGOs who were closely related to the victims raised their alarms about the legitimacy of this process. Um, Also, Anna asked what is the... Yes, yes, sorry. Mm, okay, and thank you. And now, regarding Anna's question, what is the public sentiment in Colombia regarding the war in Ukraine? Do they support it? What do you think about it? Again, it's a very polarized society, so I can only give you my perspective. And it has been more and more polarized with the years. What I can say is that the people involved with the construction of this first peace process and with the second peace process have been actively supporting Ukraine. even though in the general population there is still a lot of ignorance about it, and the current administration sadly is very anti-Ukraine, although not openly. The people themselves are very polarized. What I can say is that Sergio Jaramillo, the one of the main writers of the 2016 peace agreement that we will start like revising right now, was is heavily involved in the protection or in disseminating ideas about Ukraine. He has a group in Colombia called Aguanta Ucrania that promotes learning more about Ukraine, learning more about the injustice of the Russian invasion of Ukraine. And him and a very famous Colombian writer that has talked a lot about the conflict have basically toured Colombia talking about this conflict here. Так, дякую. Um, so, 2016 peace agreement, finally. It was an agreement between the government and the biggest armed group in the country, the FARC. It was negotiated between 2012 and 2016. Um, Outside of the country with the participation of civil society and without a ceasefire beforehand, which was an innovation from previous attempts. What was the structure that was finally agreed upon? It consisted of five components. A rural component, an end of war component, a component of victims' rights, a component of political participation of the armed actors, and a component of substitution of illegal crops, plus a verification component that doesn't count within the five. Um, this first agreement, is important to note, was met with heavy polarization. A popular vote aimed at granting legitimacy to the agreement negotiated was rejected by Colombian society with a very small margin of 50.23% of the votes and an abstention of 60% of the population. Um, which led to a sort of renegotiation, although it's important to mention that the representatives of the No movement called into question the seriousness of these renegotiations and gave sort of a lack of legitimacy to the agreement for its implementation. It also led to a change in legal status, interestingly. Originally, the government wanted to grant the agreement the status of a special agreement under Article 3 of the Common Geneva Conventions, which would have given it the effect of enhancing compliance with the narrow set of international humanitarian laws, um, but also granting it more legitimacy. Um, It also introduced this first law, the agreement in a hierarchy of laws of Colombia. It gave the agreement the same hierarchy as international laws, um, which basically have almost the same status as the Constitution. However, after the renegotiations, there was a more ambiguous definition chosen. It was no longer a special agreement, but rather one that should be used to interpret laws in Colombia when they talk about international humanitarian law and fundamental rights. So it stands above the laws, below the Constitution, but with a more ambiguous legal placement. So let's look at the different parts of this agreement. Mhm. Yeah. Um, so within this agreement, so saying there were 5 points. The most, I think, significant one when talking about transitional justice is the point on its victims. Um, it consists of a system seeking truth, justice, reparation, and non-repetition, the main components of transitional justice. And it is divided into three organs it creates: the Special Jurisdiction for Peace, an ad hoc tribunal, the Truth Commission, which is and a unit seeking disappeared people, as well as certain measures for reparation and non-repetition. The unit for seeking disappeared people aimed at finding the bodies of those forcibly disappeared. It was a humanitarian and extrajudicial body, and it has managed so far to find around 10% of the missing people, some 2,000 people so far. Well, by 2024. Um, the victims component had certain guarantees for non-repetition, which were mainly the surrender of weapons, the reintegration of guerrillas in civilian life, and certain security guarantees that are developed in the end of conflict component, and a reparations program consisting of public and solemn acts concreted with the victims and the communities themselves. These were concrete acts of reparation, such as developing projects like demining, building infrastructure, or in some cases, direct monetary compensations to the victims. Um, so I will pause for translation before jumping to the special freestyle unit. Mm. So the special jurisdiction for peace, it includes crimes of the military, crimes of the FARC, the members committed during the armed conflict. Importantly, it excludes crimes of paramilitaries, and it excludes crimes from third non-military actors, such as financiers, um, unless they voluntarily submit to the jurisdiction of the special tribunal, which has occurred but very rarely. It divided also people in two, according to whether those who committed crimes capable of being amnestied or pardoned under international law, such as those who only committed the crime of rebellion, in which case they are processed for their amnesties and left free, and those who committed serious violations. For those who committed serious violations, the tribunal establishes a mechanism to promote truth and confessions by giving different sanctions according to the level of corroboration with the tribunal. So first, those who acknowledge responsibility before the tribunal starts acting get the possibility to access 5 to 8 years of alternative sanctions called effective restrictions of liberty. It's an ambiguous term. We will get as to why in a little bit. Um, then, secondly, those who recognize responsibility, but only after the process has already begun, and basically say, I'm going to be condemned, I might as well confess, um, get ordinary prison from 5 to 8 years. And finally, those who do not acknowledge responsibility during the process get ordinary prison, but only from 15 to 20 years. So even for them, there is some reduction in the judgment. This is the departure from the prior peace process, where people who did not collaborate with truth were sent to the ordinary jurisdiction. Mm, Now, there are currently 11 cases, 11 macro cases that the special tribunal is dealing with. Some focus on particular crimes, such as sexual conflict-related crimes, and some on particular territories where the conflict was particularly intense. In the process of judgments, uh, some decisions have been made that have been interesting. I highlight that following similar rulings in non-conflict related matters by the Constitutional Court of Colombia, the tribunal recognized ecological territories as victims of the conflict due to the harm that the war had caused to the territories and the communities who were related to these territories. While innovative, this approach still has a lack of clarity in implementation. How will the recognition of the victims of these territories will help the restoration of the territories and the communities affected is still under development. There have been two final rulings so far. One related to FARC's, the guerrillas, kidnappings of people, um, where the perpetrators were condemned to 8 years of alternative effective sanctions. And the second ruling was on the militaries who had killed defenseless civilians and passed them off as rebels killed in combat to get promotions and show results. Different individuals, according to the level of participation, were sentenced to 5 to 8 years of effective alternative sanctions. Um, First of all, there is a significant delay in for these two judgments to exist, especially because more time passed between the final indictment and the judgment. That is than between the beginning of the case and the building of the case, which raises some doubts in the general population. But it's understandable given the high complexity of these cases and some issues regarding financing of the tribunal. Um, these cases are very important as they are the first time it is clear what the restorative component of the alternative sanctions will mean. So the former FARC leaders and the 12 military officials will work in projects consulted with victims and related to the crimes. Um, for example, former FARC members will be required to search for missing peoples, to educate on landmine risks, to work on environmental restoration, and to support certain memory initiatives such as installing tiles. Um, the military, on the other hand, will answer by participating in constructing community infrastructure, certain memory programs, and productive projects with the victims. In the in the tribunal's words, the idea is to work directly and sustainable on victims' redress instead of suffering a passive custodial sentence. This reflects an idea of restorative justice within this conception of what is an effective alternative sanction. The biggest concern raised with this is that these sanctions don't properly fulfill their retributive component. They are called effective restrictions of liberty to differentiate them from ordinary prison, but also while fulfilling the obligation that Colombia has under international and national law to apply effective sanctions for atrocious crimes. It is not clear whether these constitute truly, despite their name, effective sanctions. So far, we know that the monitoring of the sanctions will be done through electronic devices with georeferencing. But the director of Human Rights Watch Latin America has raised concerns about how the lack of clarity of the authorized perimeter, whether these effective restrictions will operate, will be fulfilled. Will it be the entire Colombian territory or will it be smaller than that? The agreement itself says that the space for sanctions shall not be bigger than that of the transitory zones of normalizations, which are usually between 5 and 15 hectares. But the judgment itself is worryingly silent on the perimeter. Adding to the worry is the fact that the ruling against military leaders does provide more details about the restrictions, mentioning the extensions of the zones and that they will be located in the municipality closest to the place where the restorative project will take place. This is a clear definition of where these sanctions will take place. Mm, Another concern is that the JEP has decided that the condemned ex-FARC can participate in politics so far as political activity cannot be used for negationist or re-victimizing speeches. Be- Sorry. Mhm, mhm, mhm. Yeah. Mm, thank you. Um, so, eh, when talking about the political activity of the previous guerrillas and talking about these effective sanctions, right? There is, besides the obvious issue of the ambiguity of what constitutes a revictimizing speech, um, there is a worry with the lack of perimeter, whether the lack of perimeter of the effective sanctions is compatible with this participation in politics. Um, can they go to Congress physically? Is the question sort of that has been asked. And this issue has contributed to a lot of the polarization in the country that it has lived recently, with the representatives of the North who rejected the agreement often characterizing the left wing as supporting an agreement that grants the right to go to Congress to perpetrators of mass violations. Um, a big issue is that the surveys conducted showed that Colombians would value more traditional prison sentences over lighter but redress-oriented sanctions. In general, even voices who have so far heavily supported the agreement criticized heavily this type of alternative penalties in the past, when they were being promoted and proposed for ex-paramilitary structures in the context of the prior peace agreement. In these voices' point of view, the application of restorative justice to transitional justice processes is problematic. Why? Because restorative justice as a concept falls within a framework that critiques regular forms of criminal punishment and presents an alternative to prison as punishment. It seeks not to repair social tissue by repairing it seeks to repair the victim by repairing the social tissue, by recognizing damage, by restoring the dignity of the victim, instead of just punishing the perpetrator. This position was created originally to confront ordinary crimes at a small scale. Think petty theft or battery. So applying it to transitional justice processes that seek accountability for grave violation of human rights and international humanitarian law asks to conceive of forgiveness as a strategy to overcome crime, asks um, when the crime is of such a scale, um, these pardons feel both legally impossible and ethically questionable. I say here in Ukraine, imagine the suggestion of sending Putin, for example, to build a monument in Mariupol as a punishment. Uh, it doesn't work properly. Um, However, restorative justice can be complementary to transitional justice. It gives incentives for the mobilization on the first part. And additionally, in contexts of a civil war, where parties are often both victims and victimaries, reciprocally, a formula that seeks reparation and that seeks restoration is more understandable. Thirdly, it can be used for the non-amnesty of smaller crimes within a transitional justice framework. So it's easy to think, for example, of how collaborators of an occupying regime might fall under this category. Their crimes do not amount to grave violations, and a mechanism to repair the damage they did to victims without just seeking punishment might be more appropriate way to help the community heal. It is crucial to remain cautious about its implementation. Um, but this is sort of the tension that exists with this restorative justice concept being applied to transitional justice. Mm. Now, besides the tribunal, oh, sorry, I'll actually, before jumping, or first let's finish the victims section, and then we'll go into some of the questions, because I'm not sure we will have time to get into the other components. So let's talk about, besides the tribunal, there is the Truth Commission, which was a temporary extrajudicial organ aimed at contributing to the clarification of truth, of what happened and the recognition of victims of the conflict. It um, it aimed at truth. It did not administer criminal responsibilities for the crimes committed, meaning that what was said, it could not be used automatically in the proceedings of the Tribunal of Peace. It had to do with complex processes of building trust between different sectors of society in different territories, explaining its mission, which was not only to clarify what happened in the conflict, but to build a common understanding with the society of what happened, to promote the reconstruction of society by promoting a common narrative. It didn't work out of nowhere. It worked with previous research about the conflict, of which there is many, and with existing organizations that already had a know-how on how to engage with different actors, who had already legitimacy and connections with victims and with other stakeholders. The commission included a private collection, public and private testimonies, right? The public ones giving a chance to victims to talk publicly, to give them, to recognize their dignity and resistance, in words of the those who worked at this commission. There were significant delays in implementing this mandate, partially because of the heterogeneity of visions of the conflict heard and felt within the Commission, leading to long deliberation and coordination processes, and to the need to extend its mandate from 3 years to 6 years. Finally, in 2022, the Truth Commission presented its final report, which I encourage those who are very interested in this conflict to revise. It consists of 10 volumes with over 10,000 pages, as well as audiovisual guides and written testimonies, and a digital platform containing more than 200,000 files related to the work of the Commission. The report also includes some specific recommendations about non-recurrence. It created as well, most innovatively, a network of around 5,000 civil society organizations, including societies of victims and of ex-combatants, that started to be built during the process of creation of these reports. Um, I think this final point is very important, as this, you, if you go right now to the page of the Truth Commission, you can find all of the different international and national organizations that participated in the process, that have specific expertise on some areas or other areas of the conflict, and this sort of creates a huge network of organizations that have been involved with the conflict. Now, it's important to say that some of the people involved in the Commission's work highlight the Commission's attempt at long-term peace building, and highlight its core innovation as the work of building on existing networks of peace building and human rights organization, and pushing that beyond the 6 years of the mandate. There is currently, however, deep polarization still in the country that these reports have not been able to tackle. Sadly, even recently, there have been many reopenings on debates about the truth of the conflict and specific events within it. with some sectors of some political parties and some sectors of population arguing that certain things happened and other sectors arguing that it was not like that. Um, it is obviously a very complex conflict that lasted over 60 years. It is very hard to put the past behind. Um, Mm, I see that we've run out of time, so I'll try to answer some of the questions um, really fastly. So Daniela asks whether what were the activities that were assigned to former combatants, mainly activities related to the restoration, meaning participating with communities in building monuments for memory, participating with communities in other measures of restoration. I will, and as it just means available online, yes, I believe they are. At least the press release is available online. Um, I think we can make a list of several of these resources. Also, the ecological. They were not judgments. They were more like I don't know the legal classification in English, but prejudgments. During the proceeding, these decisions were taken, but these are also available regarding the ecological matters. To send all of these, I don't know if it would be possible to send all of this through Gmail to those who participated today, to have access to these judgments, to these resources. They are available online, but to have like more direct access. And thank you all for listening. Thank you all for being interested in Colombia and Colombia's transitional justice process. Um, I hope we can continue this conversation later, and especially on Saturday, I really want to hear about um, how this can be useful for Ukraine. Thank you all very much. Ще дякую і Побачення.
Дякуємо велике. Сподіваюся, до зустрічі. І до наступної зустрічі у вас ще є час підготувати якісь додаткові питання. Відеозапис цієї лекції згодом буде розміщений разом з іншими лекціями на каналі Центру громадянських свобод на Ютубі. І всім тихого вечора і до зустрічі.